Yo, Florida employment lawyer Jonathan Pollard. I'm going to talk today about mediation one more time, okay? If you look through my library of videos, a while back I did an extensive video on mediation where I covered everything from soup to nuts in terms of how to prepare, how to approach it, the strategies you should take, the things you should watch out for. I already did that video, so I'm not going to do that again. I'm just going to give you my single best piece of advice for mediation, okay? And this doesn't just apply to employment cases. This applies pretty generally to all sorts of litigation. Employment litigation, non-compete, trade secrets, intellectual property, commercial disputes, discrimination, the list goes on and on. This is pretty broadly applicable advice. Just get up and leave. That's my advice, right? That's my advice. Just literally, just get up and leave. The other side plays shenanigans. The other side wants to bullshit. The other side wants to be absurd and make outrageous demands or take outrageous positions. Get up and leave, okay? Now, that's going to piss a lot of powerful people off. That's going to piss a lot of people off who are attached to the legal power structure, right? The entire system, okay, that exists in America, whether federal court or state court, but in these types of cases that I just listed off, the entire system is designed to get you to settle your case. And as part of that, you are going to be ordered to go to mediation. Sometimes you might even have to go to mediation twice in a single case. It's preposterous. But mediation is now a big part of the litigation process. And yes, there are some very good mediators. There are one or two mediators who are absolutely outstanding and who I absolutely swear by. But there are also a lot of mediators that are absolutely trash, okay? There are a lot of mediators that just shuttle offers back and forth, right? They don't even know the law. They don't know what they're talking about. They're just relaying offers from one person to another. I don't need to pay you $400 or $500 an hour to do that. I likewise don't need to pay you $400 or $500 an hour to misstate the law and have me argue with you about what the law is when I know damn well and certain what the law is. Okay? It's hilarious, right? And you got a mediator telling me, well, I think you're going to have a problem with X. Okay, well, we're in the 11th Circuit in this case. Here's the most recent 11th Circuit case law. You just said X, this says Y. I'm not going to have a problem. Why? Why is the law, right? Well, I don't really know about that. I mean, I'd have to read it and, give it further consideration. No, I don't need you to charge me $400 or $500 an hour so that I can, right. You're basically taking a class from me. I'm basically I'm the professor and I'm teaching you some law and paying you $400 or $500 an hour. Sorry, homie, don't play that, son. I don't play that. Not doing it. I'm gonna get up and leave, right? Go into mediation, right? And I do this in all sorts of cases. I don't just do this in discrimination case. I do it in non-compete, trade secret, everything, right? In the past couple months, okay, I've had a case where we go in. It's a plaintiff side, sex assault, and hostile work environment case. I think the case, at that point, I already thought the case was worth at least, give or take, $800,000. I subsequently have come to value the case even higher. And this is because the other side was so stupid. They didn't tap out and take the deal when they could have. And the facts just kept coming out and getting uglier and uglier and uglier. And every single time, we would, turn up a leaf, we'd be like, oh, look here, we got a declaration from another witness. The other side would say, well, damn it, we're going to take that witness's deposition. We'll show you. Well, they did, and it backfired every single time. So the case just got uglier and worth even more money. But back when we first went to mediation, I thought it was worth give or take $800,000. Okay, will we have taken a discount on that? Sure, we're taking a discount on it. If the client wanted to take a discount, take a discount. They put $500 on the table at that point, and the client says, wow, that's life-changing money for me. I just said, okay, fine, go with God. Take the money, right? That's the kind of posture, right? They came in, okay? Peanuts. Didn't take the case seriously. Treated it like it was a nuisance value case. What did we do? Got up and left. What did the other side do? Well, you shouldn't have left. You shouldn't have left. We wanted the deal. Come on, we wanted to negotiate. There was more money there. Right? What was there? What was there, right? What was there? A $120, a $130, right? On a case that I realistically say is worth $800,000? Well, you think that's an incentive for me to stay there? You think that matters to me? You think that's good enough? No, it's not. Why? Because my clients are riders, right? Because everybody knows that I'm like the rider number one, okay? I fucking ride to the end. Everybody knows it, all right? And so my clients know that, and they will ride with me And if I tell somebody like, no, that's not enough for what happened here, that's not enough for what these people did to you, that is not enough to make this right, and you need to hang. If I give that speech to my clients, 9 out of 10 of my clients are they're gonna listen. They're gonna listen. They're gonna trust the process. Okay. Is it flawed? Is it sometimes dysfunctional? Is it sometimes corrupt? Yep. But guess what? I've managed to win many cases in spite of all those different absurdities, right? Trust the process, commit to the process, do the work, okay? But so in a mediation like that, right, we get up and leave. And the other side hems and haws and says, oh, no, we should have stayed. They wanted to negotiate, okay? Why is it the right move to get up and leave? I'll tell you why, okay? A lot of people have this false impression that they can go to mediation, and during that mediation, they can make offers that are only for today, right? They say something like, I'll give you this deal, and the terms are only good for today. But today, we would take this. We would take this. We would make a deal on these terms, right? Problem is, you can't put the toothpaste back in the tube, right? Once you say, in the case, right, the example we just gave, all right? Once you say, well, we would take 200. We would really take 200, okay? That firm, 200, that's the real floor, that's the absolute rock bottom, but we would take 200 to get it done, okay? Well, now you collapsed your position, okay? You collapsed your position in the desperate bid to obtain pretty much a rock bottom settlement. And if the other side blows it up, let's say the other side blows it up, they stop at 150. They're like, no, it's a re-impasse, right? You're now, okay, a case that you think was worth $800,000 that you would have realistically settled for $400,000 or $500,000. You got fucking nervous and at the last minute collapsed your position all the way down to $200,000. Now they're at $150. Now you reset the goalpost and you've created a psychological anchor in the other side's mind, where now in their head, 200 is the absolute top. That's all they have to pay. At any given time, they want to get out, they can just say, here's the 200, right? That's what you've done. That's what you've created. That's what your lawyer has now established as the anchor, okay? And it doesn't just work like that in sort of plaintiff side employment discrimination cases. It works like that in big cases that we defend, okay? Again, within the last couple months, we've been in a mediation where in the case, the corporate plaintiff on the other side suing over some non-compete trade secret crap, right? They want $1.5 million, right? Let's just say $1.5 million. That's a common number, actually. Isn't that wild? I hear $1.5 million all the time in non-compete cases, trade secret cases, cases that go that direction, tortious interference, misappropriation, etc. I always hear $1.5 million, right? What are your damages? About $1.5 million. What do you want? Ballpark $1.5 million. Seems like you're kind of just pulling a number out of your ass, but that's just me, okay? So they want $1.5 million, right? And I tell the mediator, okay, you can go to the other side and you can tell them that Pollard says we're not afraid of any of their claims. We don't view any of their claims as viable. We view this as a case that we are going to win at summary judgment or trial, okay? So in terms of our case valuation, in terms of what we would settle this for, we're only interested in settling this for the delta, right? For the arbitrage there in terms of what it's actually going to cost to go the rest of the way. Because unlike many of the, typical corporate defense lawyers in America, right? I'm not a corporate defense lawyer. When I defend these cases, I'm defending the small business, the entrepreneur, the mom and pop, the breakaway team, whatever, okay? But unlike all these big corporate defense lawyers, now there are some good ones, there's some honest ones, but there are so many of them that just want to bill hours, okay? So they're going to steer you down the litigation path that is going to result in the maximum number of hours billed. Not me, I got my corporate clients or whoever, my business person clients, and I'm just like, look, let's do the math, right? We're going to spend another $250,000 here in this case to get through trial, okay? Maybe 300. So if we can, take that and, use that to buy the case out and get a discount on that, then it's worth considering. So if we could buy it out for $200,000, knowing it's going to cost at least $250,000, $300,000, we buy it out for $200,000, and it's kind of just cost of business uncertainty. Okay. So I tell the mediator, basically explain that to him. Tell him Pollard says they're going to lose, and we just view it kind of as cost of doing business. We're happy to flip our litigation costs into something we pay them and just put this thing to bed, right? And the other side comes back and they say they want an actual hard number. We say, okay, go with 200. Tell them we'll give them 200,000. That's it, right? That's a slight discount on what it's going to cost us to go the distance. We tell them we'll give them 200,000. We're done with this, right? Mediator goes over, comes back, and they move to 1.4 million. Okay, I'm fucking leaving. I'm leaving. We're leaving. I'm telling my client, get up. We're leaving, right? Now there are other lawyers who don't want to do that. Okay. They don't know what they're doing. They don't know the law. They're desperate. They want to stay. They want to try to play it out. Okay? Look, there's plenty of time to make a deal. In my view, my opinion, there's plenty of time to make a deal. Okay? And if you really want to make a deal, the company really wants to come to the table and get serious, okay? Then they'll do so. And it doesn't matter whether we're in mediation or not. What I'm not going to do is I'm not going to play the game. I'm not going to indulge the bullshit from the other side, from the corporation on the other side, the lawyers on the other side. I'm not going to do the folksy old-timey song and dance bullshit that so many mediators want to do. Like, my approach is we're going to get serious, and we're going to get serious in a damn hurry, or else my side is leaving. And I'm the fucking Captain Kirk of my side. So when I say we're leaving, we're getting the fuck out of here, Scotty. Okay? But that's my number one piece of advice in terms of mediation. If you go into a mediation, and now obviously you have to account for the strength of your case, okay? And I've said this before a million times. If you're absolutely screwed, dead to rights, toast, completely fucked, then you need to take a deal rather, and settle at any cost. Well, that's a different ballgame, okay? Then you're shit out of luck, and you just got to make a deal. And that's not what I'm talking about, okay? I'm talking about a case where, you're in a reasonably strong position, or even a reasonable position, a good position, right? If you're in a case where you're in a strong position on the facts and the law, then there is no reason on earth why you shouldn't approach mediation like this. You should not be desperate to settle, okay? So many people in law and litigation, they have this desperate need to settle, right? There's this desperation attached to efforts to settle, where it's like once they kind of start down the road of trying to settle something, they're like, oh my God, we have to get it done. We have to settle, right? Again, it's like anchoring psychology, okay? I don't have a desperate need to settle any of my cases, right? I don't have any cases right now that I would say it's a dumpster fire, or we're in a terrible position, we're going to lose, we have to get out of Dodge. No, the cases that we have, and in general, most of the cases that we have all the time, right? We're in a strong position. And if we were in a weak position, I would have told my client long ago, like, we're fucked. We need to get out of Dodge, and there's no need to wait for mediation to do it. We should just, go to the other side and try and figure it out. But if you're in a strong position or a pretty good position in a case, then you absolutely should just get up and walk out of mediation. As soon as people start being, ridiculous, making absurd demands, taking absurd positions, playing shenanigans, okay, fuck that. Just get up and leave. That is the way that you leverage up your position. You always want to avoid the desperate collapse to a weaker position in a desperate bid to settle the case. Instead of doing that, just keep the faith, get up and leave. Jonathan Pollard, thanks for watching. Have a good day.